Hello, I'm Ron, and today is February 5th, 1999. I've been asked today by a group of individuals if I would relay to you anything I know about the court process. Well, I've had a lot of personal experience in court in the past years, some of it favorable and some of it unfavorable. And much of the time, the favorable outcomes had to do with certain ways in which a person conducted himself prior to, during, and after trial. Well, one gets after a while to kind of know some of what the system is about and how it works. You know, I went through school, and I went through, high school and so on, but I was never taught any of that. And so that had to be learned pretty much by the school of hard knocks. Unless, of course, you're an attorney, in which some of that applies there too. They got to learn by doing. And so there was some by doing. But one of the things, when you get to studying the law, you realize that it's broad sweeping. That anything you do or say, you can find a statute that covers it. Now, there's also reason for that, but one's got to be careful what he does. And so, even exercising my First Amendment right now, the freedom of speech, the right to speak to you, has some clouds on it. It's not all that free to be able to tell you things. Because there's a statute in the states against the unauthorized practice of law. Now that more or less was set there for the purpose of protecting those in the profession. And of course we call the profession lawyers, or some people call them liars. Some call them attorneys, some call them attorneys. I don't have a lot of respect for that profession because of they produce little and charge a lot. Well, when you get a franchise or a monopoly on the right to speak in and with the law, you can expect someone to belly up to the bar and charge tremendous fees. And of course they do. And yet, people in America, are very good-natured and very honest and decent people. Well, there's a few attorneys out there that'll probably earn what you're paying them. But for the most part, when you start counting the cases and really what's happened on those cases, they weren't worth what they were being paid. Now, if you made shoes and you made shoddy shoes and you charged a large price for them, it wouldn't be too long before they would be standing on the shelf unsold. Because the word would get around. The word. And of course, if you made good shoes and they lasted quite a while and people were happy with them and they maintained their polish, their shine and so forth, and they were in style, then those were the shoes you'd be looking for when it come time to get a new pair. Well, when we talk about the law is very basic. It is very common sense. And most people possess a certain level of common sense. And so if they just knew how simple it was, they would, despite the fact that they may be a little upset going into a courtroom, they might be able to do the best possible job for themselves. That's kind of important now, because you can't really feel liberty unless you possess the ability to defend. And I'm talking about number one, uno, the big one. According to the our forefathers, this is the one that carries the sovereignty in this country. If you went across the border into Canada, they're all subjects of the crown, and the crown has the only sovereignty. In England, likewise. And so it's always the crown that would come after you if they deemed you were a bad person or you'd done something wrong. In this country, it's deemed to be the state or the federal government. But in this country, you preserve sovereignty, and you have it. So you have basically the same power as the king or the queen. But most people don't know how to use that power or wield that power for their benefit. And that's why we prepared this contract in this country. You know, our forefathers was there. They bellied up to the responsibilities that they got sick and tired of being eked out of their existence by frivolous statutes. And they stood up. They stood up and they wrote this Constitution because they weren't going to let anybody govern them that didn't live up to this contract. Now I've had people ask me, I mean, you know, what is this? This is the complete Constitution, minus some deletions that have taken place over printing over a period of time. But this can be obtained from your senator or congressman. I don't even think they charge a fee for it. But if they do, it'll be nominal. So everyone ought to have one. You see, this is your contract with your government. And who's going to take you to task here if there's a task to be taken? Your government. And so you take your contract, because they all swore to uphold this, or better have. Because there's serious penalties for not upholding this. And you take your contract and you stick it. You got to possess that. Because from time to time you may need to declare that. So today, we're going to talk about court process. Now, in all fairness to myself and those viewing, I got to give a disclaimer. I got to tell you, in all honesty now, I'm not learned in the law. I haven't been to law school. I have not passed the bar exam. I have not been authorized to practice. And I'm not. So, you can take or not take what I'm about to say. It's up to you. You got that right. All of us possess that right. So that's nothing new to anybody. But I'm going to make it anyway. And there's no intent here to practice. So, but I'm going to convey to you some of the experiences that I've picked up over the years, because I hate to go, you know, horizontal and be put 6 feet down. And all of that trouble and experience go to waste. If it can benefit one person in some way, that's worth it. And so we're going to talk about that today. You've got to understand a little bit about how we are where we are in order to be able to go from here forward. Because I'll make a prediction here. Each one of you listening to this tape will have been in trouble or will be in trouble in the future. Because the system is so proliferated now that no one is apt to get through life without a problem with the government. All right? It doesn't make any difference how well-meaning you are and how much of a stickler you are on following the law. You're going to get kept. And here I'm going to show you some reasons why you're going to get kept. Now this book here is getting kind of wore out here, but you know, there's a couple of things in here that our forefathers found that we face today. And we got to know that, because it crept back on shore. We're talking about the Admiralty Maritime Jurisdiction. People think that can only be dealt with in the sea. Well, those that are tricksters in the law took it upon themselves to bring it on the land, and you can find it in the courtroom by just merely looking at the flag. If it has the gold fringe around the outside of the flag all the way, you're in an Admiralty Maritime Jurisdiction. That's what I found, and that's what I believe. All right? Declaration of Independence. Each one of us should have the opportunity to declare our own independence, and I'm going to go through how it's done. But let's start out with the basis. Now, this was adopted in Congress July 4th, 1776. And it reads like this: "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Remember this contract that I just put in my pocket? It's as important as having a notepad here. That's it. This followed that declaration. And of course, we're going to talk about declaring this contract today, when you really need it. I got to go back here. And I'm reading from the Declaration of Rights of October 14th, 1774. "And whereas, in consequence of other statutes, judges who before held estates at will in their offices have been made dependent on the crown alone for their salaries, and standing armies kept in times of peace." Now, why was all this done? For one purpose and one purpose only. For the purpose of raising a revenue. Making money. The folding. How do we get it away from the people? And so that's what sparked the revolution, because they were tired of being had. And they had to stand up and declare their rights. And they had to back those rights up. And so that's so important to understand the basis. We have a system of courts in this country. And courts have adopted rules. Now, they've adopted these rules, and in the states they're codified, if you want to use that term. But they start out with Rule 1 and go on up in the numbers. Now, there's a book on these rules of court. There's North Dakota rules here. But pretty much all the rules correspond with the federal rules. And why is that? Well, in this contract, it clarifies there shall be but one court. And of course, that court being the Supreme Court of the United States of America. And such other inferior courts. The rules of judicial conduct are determined by the Supreme Court. This is all judges, being that they're lesser than the supreme judges, got to follow those. All right, and this is the supreme law. So all state statutes and rules got to stem from this and got to follow this. Do you see? Pretty much your whole library is right here. And that's why it's so important you possess that contract. But we got a set of rules. And we got the civil rules and the criminal rules. Now, that's what they got in this book. And I mean, anybody can have this book. This one here is by West Publishing. And I mean, they're in St. Paul, Minnesota. And so they make these books. And you can order them. You know, they'll come to you. So you can have them. There's no secret. I mean, these are not closely held by lawyers. Everyone has a right to them. But the reason I got this book and the books before it was because in court, the judges kept telling me that at the beginning that I didn't know the rules. Well, I thought I knew what was right and wrong. Well, the judge was saying, but you don't know, you don't understand the rules. No. Well, I got the book on the rules. And once I learned the rules, I ran into the next problem in the court process. Well, I'd say, Judge, yeah, but this is the rule. This is Rule 11 here. You know, this is kind of important. I mean, there's process here. Nobody signed it on the other side. Well, they'd say, well, that might be the rule. That I'm supposed to strike the pleading if they don't sign it. But that's not the way it is. What I'm getting at is there's two sets of rules in this country. The rule for you and the rule for them is different. Got that? Your rules are different than theirs. They're sitting there for the purpose of raising a revenue. And make no mistake about it. Commencement of an action. I mean, it goes, happens to be Rule 3 now. A civil action is commenced by the service of a summons. Now, you know, they got the civil rules in here and the criminal rules in this book. Well, what did it say here in Rule 3? A civil action is commenced by the service of a summons. Prior to that, it said, there shall be but one form of action, a civil action. Well, I'd like to run through with you legal process once that, you know, that I've had to go through. My family's had to go through. So that you can see. Many listening to this tape will already know about this. This would be an infamous traffic ticket, generally known as such. All right? There shall be but one action. And that's commenced by the issuance of a summons. Well, guess what this is? Right up at the very top of it, it says summons. It says civil action, summons. Well, then how come everyone believes that this is a criminal action? I mean, it fits the rules. Not only is it a summons, it's also a complaint. And whenever you issue a summons, everybody assumes that there's a complaint. Well, it says complaint at the top of it, but is it? You see, there's a little trickery going on in the legal process. One, most people think now they're cited. There's a criminal process. But it's a summons, which is a civil process, and it's also a complaint. Well, here's the most fabulous thing of all. Guess who served themselves their own summons? The person that signs the summons. Now, there's usually, not always, but usually, two distinct signatures that can be derived from a summons. One, a police officer, and one, yours. Well, they got the old trusty contract, and what is the first right when you question the process, whether it's civil or criminal, can't be compelled to testify against himself. And so the best thing a person can do when stopped, when detained, when trouble is noticed, is this. And you know, this one here's got a pistol grip on it. And I mean, this is the most important part of law of all. And this is what causes the most trouble. People don't do this. Now you watching? Can't hear a lot, can you? If you can't keep your mouth shut, you got the picture? Because most rights are waived by opening your mouth. Keep it shut. A lot of trouble would go away right there if the officer involved or the deputy or whomever would not get your confessions right at the point of the alleged incident. Not your job, man, to testify against yourself. Not your job. As a matter of fact, it's a good way to waive your contract. And you know what? Most do. Most do for some reasons. One, they're scared. This isn't an everyday affair for some. So they're scared. They don't know how to apply their rights. Don't know how to keep their mouth shut. Don't have to cooperate, you know. Officers are trained how to interrogate. And get whatever it is they think they want or need or can suppose on paper. Now, by the way, officers lie. They'll actually put their lies on paper. They'll actually sign them. And if you catch them in a doozy, they'll actually move them off into Canada while you're having trials, so you can't reach them with a subpoena to catch them on the stand lying. Now, but they're so good at lying after a while and running the process as they see it, not as the law is, but as they see it, that you can oftentimes get them on the witness stand in court and catch them in that lie. Because what does that do to their report, which is supposed to be the basis under some claim? Now, you're to be held for only what you did when they prove it. That's what this contract says. You can be relieved of money only after they prove it. Well, they've created courts in this country that are so good at what they do that it actually amazes me. Now, if you think that I'm not telling you correctly here, what you want to do, though, is take just a few minutes of your time and go visit a court while you can walk in the door, sit down, you know, because these are all supposed to be public forums. These are supposed to be speedy trials. These are, you know, and there'll be motions, and there'll be all kinds of things you can pick up in there and watch others go through. But you will see the process as it really is to most people. But I have a real problem with the way they're handling that because there's no due process in it. But sit there and watch it. And you will see a bad scene. You will see a sheep shearing contest second to none. They'll run them through there oftentimes, one every 2 minutes. and they will get clipped. One of the reasons they get clipped so easily is because people resign themselves to the fact that they don't know how to defend. Therefore, they'll plead guilty and just pay, whether they violated any law or not. Just pay, just get rid of it, forget it, go on with your life. Well, it's not that easy. There gets to be residue from pleading guilty. One of the residues is you become an easy mark. They know they can tab you, tag you, give you a citation or a ticket or charge you, and you'll go right on in there and you'll just walk up to the podium, you know, and you will plead guilty and pay them the money, which is all they're after in the first place. And so you're an easy mark, so you can expect to be hit numerous times through your life. As a matter of fact, whenever your name or plate comes up on their computer, they'll know whether you're an easy mark or not because it's denoted on there. And kazingo, well, we're in for another 150, 250, 500,000, 2,500. You hear me? Yeah, they already know what kind of a mark you are. And of course, if you're the other way, you insist on justice and insist on the system complying with the law, and that they have to use that legal bulldozer to find you guilty, then it's not so profitable anymore. And when you become notorious to them on that basis, and some officer who is an upstart who doesn't know what's going on will run you up on the machine, uh-oh, there's a little mark there. And there's a designation there that this person ain't worth the money that's fixing to be spent on them. Now, at that point of time in your life, you can experience some real liberty, some real freedom that everyone should have in this country. That's kind of important. So, we've got here a tier of courts in this country. Now, remember the Supreme Court and then these inferior courts all the way down? Courts of appeals go below them, federal district courts, and we've got state Supreme Courts, and we've got state district courts, and then, of course, we've got municipal courts. And I've been asked today, to cite experience, from the lowest court and bring it on up as far as I can get in this tape. Let's talk about a municipal court. Municipal courts are courts that were generated by municipalities, cities. You hear me? Cities. What for? For the purpose of raising a revenue. They give the appearance of being courts at law. Well, boy, that's hard to find, because most of the judges in those municipal courts have neglected to take the oath to uphold this contract. And that gets to be a problem. When they can't uphold this, or haven't sworn to uphold this contract, no one can get them for perjury. You're operating in another jurisdiction, a foreign jurisdiction. Now, that's a problem with that. Where's your rights? But there's one other part about a municipal court, and that is they're courts of no record. No, like in NO. What's it about no you don't understand? No record. That no one in that proceeding is keeping a record of the proceedings. There's no court recorder there going, keeping a running tape of who's saying what and what they're saying. So there's no record. Now, if you lose the proceeding, the judge will generate some records then. However, if you win the proceeding, the judge will never issue an order of dismissal or acquittal or anything of that nature. I mean, I've never been able to get him to do it. No record. So that is the system that was set up using the minimum of formalities. Just give the appearance that we got a court so you can walk right on in there and be fleeced, defleeced, and pay, you know. Don't bother going around the corner to attempt to get justice. Go right on straight to cashier and pay. That's what that system was set up for. And it raises millions of dollars of revenue in the community. In some communities, it's way over that. Why? How do they get away with that? People do not assert their rights. That's how they get away with it. People are not taught in school how to assert their rights, so how would they know? Unless they've been through it. And so if you're one of the fortunate ones, now not unfortunate, but one of the fortunate ones that get something like this, boy am I lucky, I'm going to learn the process now. You know, but remember rule number 1. Not your job to testify against yourself. Just not your job, man. Okay, so we go on. Now we're dealing in this court of no record. You know, it's kind of interesting, you know, because here we got a ticket. You know, I checked with the Bar Association here on this here officer here. Do you know that he's not authorized to practice law? I mean, this officer here, he's not authorized to practice law. So what is he doing signing moving court documents? What? What's he doing? You know, there's something I always want in any of these processes, and that is I want a formal complaint. That's the long form, you know. And I don't care how many pages they got to have or how long the pages are. I want the formal complaint. You know why? Guess what? See this here? 6th Amendment. I have the right to be informed of the nature and cause of the accusation. 6th Amendment. Nature and cause. I want to know everything there is to know about the nature and cause of the offense. Obviously, this police officer here has no idea what that is. So he might not put down a couple of words. Or even, he's even got 3 lines here he can use to put down a couple of words, but most of them are not intelligent enough in the law to be able to fill out those 3 lines. I mean, they're just used to doing the simplest possible. Now this is supposed to convey something to you. You know what, to most people it conveys to them. But I have a real problem with this. I have a real problem with it, and that is I don't understand the charges. I got to have the full formal complaint. You know why I want that full formal complaint? Because I want some attorney somewhere who's authorized to represent these folks that claim they're moving against me to be licensed to practice law. Or at least give the appearance they got a license to practice law. Yeah, I want to know if somebody learned in the law has prepared this complaint. Because you see, and you can start to defend. You can't defend until you know what it is. Yeah, well, if you think that this is something, and you, on the basis of that thought pattern, come up with a great grandiose defense, guess what'll happen? They'll change it. You see, I want pole barn spikes. These are long nails with screws on them, you know, that when you pound them in, they hold things together absolute. That's why I want an attorney signing the complaint, because that is it. Till then, there ain't been none. Just the appearance of one. Yeah. I want to tie this attorney down so that there can be no changes. That way you can prepare a defense when they're plastered down, nailed to the floor. They can't move their feet. And change that complaint. Yeah, remember now, this whole system there is, so far that we've talked about, is for the purpose of raising a revenue. Now, do you think these people on the other side aren't innovative? Do you think they won't lie, cheat, or steal? Well, you better take a look in the mirror. Because, and just say to yourself, they will lie, they will cheat, they will steal. And then look at the person in that mirror who's going to defend. Because that's the one that is. Yeah, so we're dealing in courts of no record. Oh, yeah, I mean, their witnesses come on in and they take the stand, and I mean, it gives all the dog and pony show. You ever been to the circus? There you're going to see one there. I call it the legal circus. And you know, it's so funny that some people get, after being harassed, you know, and probably don't have all that much money, are standing there and they're being browbeat, you know. And the judge, he's never in good humor, it seems like. I mean, that's part of the dog and pony show, too. He'll get so angry, he'll say, all right, I've had it with this process. Just tell me what I owe and I will pay it and get out of here. Well, what did you think they were asking for in the first place? Yeah. I had a friend of mine that I know, call him Lyle. He was so angry that he had gotten a ticket. He didn't deserve it. He absolutely knew he didn't deserve it. His wife was a witness. She knew he didn't deserve it, hadn't done anything wrong, but he demonstrated an out-of-state plate on the vehicle. Well, that's always prime for a ticket, because they never think you will show up to defend. You see? It's just straight go straight to cashier. Don't bother about due process or law. We just write the ticket, and he'll either got to show here or pay, or we will inform the other state to cancel his privileges to travel. Should I say drive? Anyway, he goes. And of course, they ain't doing nothing right, you know. And he kind of knows that, but he gets so angry in the middle of the process that he just basically says, tell me what I owe, I'm going to pay you and get the hell out of here. Well, that's what the whole deal was in the first place, and he fed himself right into that scam. Perfect. When he told me about it, I rolled off my chair and onto the floor. I thought it was so funny. I mean, you don't get humor like this on television. He just bent me over big time. Yeah, he's the one that got had because he couldn't control his temper. And don't ever display temper in the courtroom, because then they know they're getting under your skin. You use all the politeness that any country gentleman would ever be able to administer. But it's got to assert your rights. Otherwise, you're considered to be a fool. And nobody likes being made a fool of. I don't care who they are, what nationality they are. All courts of record or courts not a record, have to use the rules. And so you get to know what the rules are. They're not that difficult. Now, at any time that any court does not uphold your rights under this contract, it's time to motion to dismiss. Yeah. every day, every hour, every minute is a good time for a motion to dismiss. As a matter of fact, I've been in proceedings where more than one motion to dismiss was made in the same day. Several, as a matter of fact. Because one generates the paperwork for the motion to dismiss and on the constitutional basis and on the deficiencies on the other side. And I want to tell you something. You have no idea the vastness of the deficiencies on the other side. Once you get into a case and start looking, looking for the deficiencies, unbelievable. You couldn't believe that they're running a system so shoddy as that. But they are. And so you need to. Anyway, I wanted to give you quickly here, this is kind of important now, on the Rule 11. Now this is a civil now. And you see, that's what a summons is issued off a civil. My goodness, warrants are issued off a criminal process. Understand? It's got to be supported by oath or affirmation of probable cause. Somebody got to swear under oath that you did something wrong, for the criminal process. So this starts out civil. And, until the court obtains the contract. And guess what the contract is? If you didn't sign this contract, the contract will be when you enter the plea. The entering of a plea, whether it be guilty, not guilty, or some 6 or 7 other pleas, that will be the contract for the criminal jurisdiction. Now, I was told by an old scholar years ago that criminal jurisdiction is by contract. Your job in upholding your constitutional rights is to watch what you do with this and, of course, take them out. Not your job. Not your job to sign their paperwork against you. It's just not your job, man. Don't be doing that. Because if you waive your rights, then they think they can do it to somebody else who will waive their rights. Nobody ought to waive their rights. I'm all for prosecuting people who commit crimes. Are you hearing me? Crimes that endanger Americans, that hurt Americans. I'm all for that. But fleecing Americans and using the same process for that? No, I ain't for that. And I don't want any of these rights given up. But here's the Rule 11 thing that catches the eye. If a pleading motion or other paper is not signed, it must be stricken unless it is promptly, it is signed promptly after the omission is called to the attention of the pleader or movant. One other thing it infers, and that is the person that signs this has to be authorized to practice law and contracted to represent the municipality, the county, or the state, or federal government if it's a bigger case. You hear me? What's this signature worth on here? Basically nothing more than a witness. That's it. Says ain't nothing. Matter of fact, a friend of mine took one of these and put it to a deposit slip, because you see it had they even went so far as to put a dollar value on this violation. This was a $40 valuation. Well, on this one here, there's $100 on there. You hear me? And of course, this friend of mine, he signed this here, because he didn't want to be taken out of his vehicle and put in a can that night. Well, it's kind of an inconvenient time, but sometimes you got to do what's necessary to support your rights. But anyway, he signed this here. And so his was $40. And he didn't know exactly what to do with it, and he thought, well, gee, it must have value. It must be a contract. He signed it, and the officer signed it. And so, guess what he did? He clipped that to a deposit slip. Yeah, to first checking account, deposit slip. He clipped it to that, and mailed it to the bank and told him to deposit that amount to his account. Or, if they, under banking rules, they have 24 hours upon receipt of a negotiable instrument to deposit to his account or reject the instrument. Because this is deemed to be a negotiable instrument, it's to get you, it's a contract, no question about that, and you go trotting on in there, and it must have some value, mustn't it? Well, the banker rejected it, claiming it had no value. Well, of course, this is going to come to court, as a notice to appear also, so you go to court, and this friend of mine, he subpoenaed the president of the bank to come be the witness in the case. Yeah, well, the president shows up, he's subpoenaed, and he takes the stand, and of course he asks him about this instrument, if he recognized the instrument. Yeah, well, this had come in to the bank on a clip to a deposit slip for it to be applied to this such account. Well, he said, you didn't honor it. He said, no. Well, why not? It has no value. What? It says $40 on it. Well, yeah, it does say that, but it has no value. You see, one thing under contract is there has to be consideration. Now, I know that from studying contracts. There has to be consideration given on a contract. That means there must be value there. Well, this banker, and bankers ought to know what has value and what doesn't have value, right? Well, this president of this bank says this thing absolutely had no value at all. And so this friend of mine moved to dismiss the case. And the judge, who may have been dozing off, decided that this case was going to be more complicated than they wanted to deal with. And so, of course, he dismissed it. Value on the contract. There is a very, very important part of any process. And that is your understanding. Do you understand the cause of action brought against you? And I got this problem. I've been studying law and studying law and studying law. And I could never understand the charges. Basically, it's not my job to understand the charges. But you know what will happen if you don't understand the charges? One of the funniest things known to man. You will be appointed a public defender because the court has to know that you understand the charges. So they've got to appoint somebody that they already have a contract with. Are you hearing me now? That they already have a contract with. It's also known as a public defender agreement. They already got a contract with him. And his job, when appointed to you to help you now, boy, I better put quotations by that word help. You can help somebody up or you can help somebody down. So what's the help? Remember that word help. His job is to give the appearance he's going to help you, but indeed his job is there because there's a jurisdictional problem. You see, you don't understand the charges. And he's supposed to be learned in the law and authorized to practice, so he's got to be appointed to understand the charges. And because he holds a contract, mark my word, he will understand the charges. And of course, then you're up for the contract yourself, and it's called enter a plea of guilty or not guilty. But prior to that, you oughtn't to waive all the questions of law that you have. Because they'd like to zip you from here into trial of facts, where you've got a 98% chance of losing, because they'll stack the deck if nothing else. Let's not get past these questions of law, which is always dealt with and has to be completed prior to enter a plea, because you got to know what it is you're pleading to. Not what some public defender says, You got to know. And of course we got this here, this rule here. And let's just jump ahead here and look under Rule 16. Discovery and inspection. See, you have a right for the prosecution, whomever they are, to disclose to you every single thing they got prior to entering a plea. Are you hearing me now? Prior to entering a plea. Discovery. You want it all. In the larger cases, it's under Title 18 of the United States Code, 3500, known as the Jinx Act. They got to furnish you everything. And you know what? In many cases, they don't furnish much at all, if anything. Well, that's kind of nice, you know. If they don't comply with the law, that's kind of nice. You know what? And if you don't make the request now in writing, you waive your right to the inspection, to all the information, who the witnesses are going to be, what they're going to talk about, all of this, any documents, logs, you know, anything where they got as proof against you that you might have violated the law somewhere. You have a right to that up front, and you have a right to see it prior to entering a plea. How can you understand the charge if you don't know what the evidence is? And if they give you a lot of evidence, you get a chance to go over it, and you can tune your plea to fit accordingly. You know? You know what I mean? Yeah. And of course it may be a plea of not guilty. You know, it may be. But anyway, you'll be in the criminal jurisdiction as soon as that plea is entered. And you will have a waiver of your most basic rights when you enter that plea. So you want to be sure you know what's going on here before you waive them rights. And guess what happens if they don't produce anything or much of anything? When it comes to trial, you can object to it because they didn't furnish it in discovery. And so they're not entitled to use it at trial. You have a right of objection in all that process too. Now we've been talking how about municipal courts, you know. Municipal courts is like the schoolroom. When you went to school, you sat in the schoolroom. Keep you out of the elements. Well, municipal court is just like that of a classroom. You can go through all of that and all of that process and sharpen your pencil, you know. Tune the mind a little bit to this whole process. And when they get all done, what have they got? They got a court and no record, and they still got no claim even if you lose. Because you have a right to appeal that to a state district court that's held in your county. Now you got a right to due process of law by a judge who has signed an oath of office, who is obligated to administer this contract. And of course, having gone all the way through this here on a dry run basis, you now can go further before the real thing, knowing everything that you now know. And there won't be a so-called city prosecutor on you at that point in time. It'll be a county attorney or a county assistant attorney. And he may not have the benefit of all the bullshit that was pulled on you in the lower court, in the court of no record. And so, but now you is ready, you know. Now you can do things right on this appeal. And then try this thing. And of course, if you want a jury trial, fine. But we got problems with juries. You know, they even have some jury trials in municipal court. Can you imagine 6 people sitting there ruling on something that don't exist and wasting their time? Yeah, trying to administer justice and watching the dog and pony show, you know. Well, you can get to a trial, you know, by a jury. She got a real problem with the jury. And I'll tell you what it is right now. I could never win before a jury. Never, ever. Never, ever. Because they're all hand-picked. I've had people say, Ron, that's not so. Yeah. Yeah. They're hand-picked. Make no mistake about it. And in many of the counties and municipalities in this state, they're hand-picked by the prosecutor because the clerks don't know how. So you're going to have a choice of a jury picked by the prosecutor, already tuned to the prosecutor's philosophy, or not having a jury. Remember, once a jury makes a determination in a court of record, that decision cannot be overturned except for by mistake of the judge. So you have two kinds of trials in this country. You have a trial by judge, and then you have a trial by judge. I didn't make no mistake there. Trial by judge over here and trial by judge over there. It's much easier to win on appeal to the North Dakota, if you want to take that for example, the North Dakota Appellate Court, or to the North Dakota Supreme Court, if a judge has made the decision based on his bias and prejudice, because he's supposed to know the law. He's supposed to administer the law. That system has gotten so easy for them to do because of people being so willing to plead guilty, to waive their rights, to pay, that they've gotten so unprofessional that anybody that stands up for the contract and carries it out, in the final analysis, in most cases will prevail. Because they don't know how to do anything right. I mean, it's that bad. And I am not stretching the truth on that. It's what I've experienced. They aren't doing anything right. So the law has common sense to it. And you have some common sense. Why not learn how to feel free and protect your liberty? Jeez, most of you listen to this got a long time to live yet. We've got more and more encroachment on our rights by legislatures every single time they meet. North Dakota right now got 1,000 bills. How many of those bills have been presented by we the people to have the legislature pass something that would benefit us? You want to hear this resounding number? Watch out so I don't break your eardrums. None. None. These bills that are in there, most of them have been put in by government to benefit them. And that's what you're up against. Now, in order for many of those state statutes, state century codes to apply to you, you got to do something about waiving your rights in here. It's called contract. Here, many of you have waived your right to travel freely and unencumbered for a privilege known as a license. That's a privilege to drive. Okay. Not very long ago, I was privileged to visit a hearing officer here in Fargo. A hearing officer that hears on an administrative basis the arguments as to why these privileges should not be canceled or why these privileges should be restored. And he dug out his old book on the administrative process that just has to do with driver's license, and just what the government selected out of the code that would benefit them in the control and use of these licenses to drive only. And the book was this big. You hear me? Just the administrative law under that contract, just that one contract that you walked into some license bureau, driver's license bureau, and signed your name for. You had no idea that there was that much law that affected that simple document known as a driver's license. That's the administrative procedure. You aware of them? You're holding the license, and so you've contracted yourself into this giz now. And this is the law covering you. You hear me? And so, you know, you got to use this now along with this for defense. Yeah, there's all kinds of avenues there. And the one thing that's so funny is there's so much in there that not even the hearing officers know it all. They just know a few of the paragraphs that they use mostly. Are you hearing me? And so you got all kinds of chances. Here's another one here. This is unemployment compensation law. Just look at that. Wow. When your employer pays in, you know, and actually you do, whenever he pays in on your behalf, he's paying in out of your check. Like it or not. All of this administrative process and rules and regulations and requirements is your contract too. Your money going in. How are you going to get it back if you need it? Well, you got to put up with this then. And you know, these bureaucrats that work in that system, they got such a phenomenal way of thinning you out by making it so difficult for you to prevail that most people will just give up so then they don't have to pay out the benefits. Ain't not your job to give up. If you're in that contract, you make sure they live up to that contract. Your job. Because if they just can mow a whole bunch of people down like mowing grass, system don't work. It's broke down. It won't benefit you. I wish they had officials in those capacities that knew the law, but they don't, and you can never assume that they do. Because if you assume the other way, you'll be right most of the time. So make the other assumption, you know, and use the process to your benefit. Okay, we're going back. We're to this municipal court now. This court of no record that, in all practical purposes, doesn't exist unless you agree to it. So the only time their decision stands is if you just say, well, now I've had enough of this, and I didn't go this, and this seems to be acceptable, and I guess I'll just have to pay. Well, if you agree with that, then they'll take your money. Are you hearing me? They won't even give you a handshake after they take your money. They won't even give you a kiss on the cheek. They'll just take your money. And they'll spend much of that money using it against you. So you really ain't over with it, even though you pay and walk out the door. Do the process. It's your process. You have a right to it. Run it all the way through to the Supreme Court of the state of North Dakota if you got it. And of course there's one step higher than that, the United States Supreme Court. How do you think there is good case law from the United States Supreme Court on the records because everybody in this country laid down their rights and paid no attention to them or didn't uphold them? No, it's because people who did. That's why we got some good decisions from the largest court and the one with only authority in this country. So you can't give up. Now, in order to be able to defend yourself, you've got to stick close to the contract, especially on the 4th, 5th, 6th Amendment. The 8th Amendment applies also because there can't be an excessive bond. And so if you're indigent, you have a right to sign a personal recognizance bond wherein you certify that you will return to court on the time and place so designated in your notice. You know, that's important. You know, you want to be there. Don't advocate to anybody that they not appear in court. Be there. Once you fell into the process, I mean, you know, as a citizen of this country, you're duly obligated now to follow it through on due process. But the 8th Amendment is so important because if you're indigent, you got a right to get out of jail on your signature. And, you know, at least at first, you know, people don't generally like jail. And of course, that's why they have jails. Well, that's one of the reasons, let's put it that way. The other is to hold people that are really dangerous and really damage other individuals in this society. But many of them that are there because they waived their rights, not because they were a danger to society or injured anybody. You know, so there's that part there too. But when you're there, most people, at least at first, want to get out. And so you got it right there. Excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. Oh, they're going to lay a glove on you in there. And they better not be cruel to you. They got to feed you and provide you. If you got a toothache, they got to get a dentist in there. You hear me? If you got to have certain medicine, you got to have that too. I mean, this is not a life and death situation now. They got to provide these things. And of course, you got a right to use what is known as a writ of habeas too, if you're being unconstitutionally charged. A writ of habeas corpus. That'll probably be a conversation for another tape or something like that. But there's a number of ways. But one of them is to just sign a promise to appear, and then you can be released. Money is what they're after, and so why do you ever disclose you have any? Not your job. It's not your job. Apply rule number 1. If more Americans did that, there'd be a less frivolous arrests being carried out here. You know, in this community, it's so unsafe that even your car's at risk. We have the largest car thefts in this community per capita than anywhere else in the nation. We have the most wreckers to pick up cars per capita than anywhere else in the nation. And we have very easy incentive. It's called purpose for raising a revenue as to why people's cars are taken for the most part. You see, you're the lawful possessor of that vehicle. And in order for anybody to remove it, they've got to contact the person that's on the registration. And that registration is kept in Bismarck. And they got to notify that person to either move the vehicle because it's obstructing the public thoroughfare in some way, or they got to give notice that they'll move it. But what do? They go straight to cashier. They hook on to the thing, zip it on out to some fence that they've got. And by the way, if you check the fences lately, they're doubling in size fast. Now, this is a profitable industry. People even give up their right to possess. And then they go pay. Well, let's see now. We've got a $10 charge per call, and we've got $50 hookup, and then, of course, we've got yardage, storage fees apply to this car. Zick, zick, go straight to cashier. Not only that, this wonderful city of Fargo pays a criminal, in my opinion, now, just my opinion, $1 million a year just to stand by with his records to steal these cars. And guess who notifies them of many of these cars that need to be stolen? And I call them stolen whenever they don't have the lawful possessor's permission. Some people call that owners, but that would be a misnomer. Lawful possessor. Permission. Well, we've got people running around this community with scooters. Now, they run around and spot. They spot cars that are subject to be stolen and steal them. They put in the information. Put a sticker on it, something on it, or phone it in on their radio and have somebody come with one of these records and right out to the impound. So we got them. They're not even officers of the law. They're impersonating officials. Don't even have the status of a simple police officer. They're a nothing. But they run around as the point person for stealing vehicles. Then we got the police officers, who all conduct themselves in that manner. Oh yeah, get this thing towed. Get this thing towed. These are all numbers. Cash register is ringing. That's a big business in this community. to steal people's cars. Now, I've done some research on this because it's gotten so far out of hand. But you know what there's no way anybody can prevent? That's the people's willingness to pay the extortion to get their vehicle back into their possession. Are you hearing me? And you know, you got every right to just pay these thugs, these hoodlums, these car thieves. You got every right to pay them. And the majority of you do. But how many times are they going to take the car you lawfully possess and milk you of money before you say, that's enough? You boys need to be prosecuted for this. We need to ring your cash register in our behalf. Need to do that, people. Because 80% of the right of liberty is the right of locomotion. And if they steal your right of locomotion, i.e. this automobile, you're being deprived. Not to mention the theft they're committing and the extortion that they're holding up here. These are simple things. You can go all the way through these and not lose anything other than what they claimed in the first place. But gaining the education now, that's where it is. And you don't have to do it too many times before your vehicles will possess the same liberty you possess. They'll be where you left them, and they'll be ready to use when you get to them. And they'll be in your possession. You can't give up. I mean, that's the biggest sin being committed in America today. Giving up their rights. Remember now, a lot of people died that were born in this country. To uphold this, and you will, for a few dollars, waive it. If you waive it, you do not deserve liberty. You do not deserve freedom. And I can assure you one thing. You waive it, you won't have it. We have a paper system here, so everything you do in the system, be sure you put it on paper. In order to assert your rights, you must do the documents. And it's okay to sign the documents you prepare because you're preparing them for your behalf, on your behalf, to benefit you. Now you got to use the pen for that. You hear me? And you got to record these. Now there's rules in here as to the length of time. General rule I read is you've got to have your papers in 10 days before the motion, for a hearing, so that the other side has an opportunity to respond. I've seen them filed now. I know this is aside from the rules, but I've seen them filed just 24 hours ahead of the hearing that was scheduled. The reason for the rules on the length of time is to give the other side reasonable time to respond if they wish to. The same courtesy's got to be afforded you. And so courtesy is a part of due process on both sides, not just your side. Are you hearing me? On both sides. So exercise courtesy and exercise politeness. This man sitting on the bench may have not taken the oath, and he may be a crook of the first magnitude. But you see, he's sitting in that chair. You hear me? You ain't, he is, or she is. And so you give him all the due respect of the office. You don't have to respect the individual, but the office. And without that respect, you've got chaos. You don't have any system of laws. We've got a lot of laws in this country. Believe you me, we don't need another single one. We can spend the next 100 years getting rid of the surplus in laws we got. And we won't even have probably scratched the surface on getting rid of those in 100 years. You look at all the years it's taken to create them all. And you have legislatures in every state meeting, and you've got the federal legislators in Washington meeting. And I'm telling you, I mean, You know, just like last year, they added 800 pages to the Internal Revenue Code. Well, my goodness, you know, 800 pages is a book this size, just 1 year. Can you imagine how cumbersome that thing is after a while to disguise the real meaning of it? You got to keep it simple. Assert the rights, let them know by asserting your rights. You ain't about to be mowed over here. If they beat you, they're going to have to beat you fair and square. You know, but it's very hard if you haven't done anything wrong for them to beat you fair and square. You can always win in the final analysis because they're creating stuff out of thin air. Recently, I watch videos once in a while too. A guy by the name of Struckhutter said how any idiot can beat a traffic ticket, or a speeding ticket. And he cited a very important case, a case which will jeopardize into each one of the states here. The various premise that the other side must prove to find you guilty of a speeding ticket. Just fighting the facts on it. We're not talking about the issues of law now, we're talking about just issues of facts. Most of those are never done correctly. It's just presumed by people they are. But that's a good tape. I mean, if you want to get one to review, I mean, Mr. Struckhutter, I believe, is a preacher. Well, this preacher got tired of being had. And he decided to preach a little on tape along with follow-through. And, of course, he won at the appellate court level on this particular ticket he talks about. His personal ticket. Got all the right in the world to talk about that. So watch that one of him. You can get it. You know, it's available. And you can contact the people that handle these, and you can get that tape. But you can contact him straight away too. That's important. Now, public defenders. Remember, the court must have jurisdiction. Jurisdiction is made up of two pieces. They must have your body, that's personal jurisdiction, and they must have subject matter. I refer to this to material jurisdiction, but subject matter is the term they use. In order to get subject matter, they've got to get you ponied up and plead. You hear me? They got to get you to pay, enter a plea. And in order to get that, in the final analysis, they will appoint you a public defender. Now, the public defenders, for the most part, are there to give the appearance of due process. You see, in the Fifth Amendment of this great contract of ours, you have a right to due process. They must see to it that the appearance of due process is there, or otherwise they waste their time. So they'll appoint a public, I always keep saying pretender, to be sure that they got jurisdiction. Because they already have a contract with that boy or that gal that they've signed. You know, if anybody's going to appoint you a public defender, get a copy of that contract. It's the contract they signed with the judge. Hearing me? Oftentimes they're also signed by the prosecutor or some other official in the courthouse. And, of course, this attorney. Or, like I found, where the contracts are written with a non-existent company and this attorney merely shows up to represent. I mean, that happens too. These contracts are signed with companies that don't exist. Don't file taxes, tax returns, don't have a taxpayer identification number, nothing. I mean, that's who they got these contracts with them. Some of these places. But some of them are with these individual lawyers. Anyway, whatever lawyer shows up as the public pretender, you know one thing. You're fixing to be fed in to that jurisdiction, just like putting a bundle in the apron of a thrashing machine. They must give the appearance of due process of law. Not only that, though, if you needed some help, you know, and you feel you can manage a public defender or a lawyer, you have a right to assistance of counsel under the Sixth Amendment. It's the very last line of it for your defense. And you might be able to use them for some things if you learn how to manage this project now. Otherwise, you get to lose. That's what's going to happen. But you got to be able to manage, because you can get them to do some things for you if you know what it is to do. A friend of mine just recently, he went through 2 of those public defenders because he wanted them to just do a simple motion to dismiss. And he gave them all the facts that he had to do it. Well, these public defenders, I don't think either one of them had ever done a motion to dismiss in their life. Probably didn't know how. I mean, they certainly didn't do one. They wrote letters as to why they hadn't gotten one done. Several letters. But that would should have taken half the time to prepare the motion and the affidavit in support of it. And they didn't do it. And it was certainly there. But it wasn't their job to get the person off of the charge. You understand? But this one public pretender, he kind of knew at this. Been out of law school a year, you know, been practicing, needed some income, and so he arranged for the firm the contract in this county. And this county is north of us here, and I got quite a charge out of reading the materials. It's kind of funny. The first attorney ran for the foothills when he realized that this defendant knew something about the law. He didn't want nothing to do with anybody that knew something about the law, so he ran for the foothills and got displaced by the judge, and a new one was appointed. Well, this new guy, he'd been at this now just about a year, and he was appalled at the process. And he made a phenomenal statement. He said, all they're interested in the court system here is money. They're not interested in justice. Now, I see, here's a man new on the scene, you know, who went through law school, who believed that the effort you're to put forth here is to obtain justice. But he said, all that court process in that county was interested in was money. They didn't care at all about justice. Now that comes from an attorney. That's phenomenal. In this public defender contract that he was involved in because of this non-existent company, he was to be paid $690 a month to represent indigent people, people who couldn't afford lawyers, people who got a where the court couldn't get jurisdiction, and the court's job then was to appoint somebody to get them jurisdiction, which is a public defender. And he got, like I said, $690 a month according to the public defender agreement. I mean, I even saw the agreement. Yeah, really did. Some of the agreements are written so bad that it's right on its face that the public defender can't defend anybody. He's restricted. Well, in this one, it existed too, but in a more subtle way. This public defender had to be asked, how many clients had you been appointed to represent? I mean, how many cases was he the public defender on now? Well, he said 30. Well, take 30 and divide that into $690, and you could tell that $23 per defendant was going to be spent. Now, the prosecutor has the ability to spend millions of dollars on their case. You think that'll compete with $23? Are you hearing me? No. The fact that that disclosure is there shows that it's monetarily, financially impossible for any one of those 30 defendants to get a defense. It's out of the total realm of impossibility. I mean, it's just impossible. The word can't happen applies. No one of those 30 can get a defense. But why is that all done? To give the appearance of due process. That's why. It's a scam. When this attorney realized, just because of this one guy that was asserting his little bitty constitutional rights, not a big buck at all. He said, this system really sucks, he thought, as a lawyer. I don't want to be a part of this scam any longer. And he tendered his resignation for this non-existent company to the county. Saying, I don't want to do this no more. Scam. That's what it is. Didn't want to do it anymore. Well, that's the way it is. For those of you viewing this tape, if you haven't already lived it, or in the process of living it, you will be living it in the future. Prepare yourself. There's so many simple things you can do to protect yourself. Okay? Let's kind of review these. Watch this most dangerous instrument known to man. The only thing you can sign, in my opinion now, just my opinion, here, is the personal recognizance bond to get out of jail. If you're capable of getting enough paper and pencil to work, you can do a writ of habeas corpus for yourself. Because you're probably being held unconstitutionally. Most cases that's the case, not all, but most cases. You can prepare your own writ of habeas and have the jailer bring it to the attention of the sheriff or the clerk of court for administration. Those things that you prepare for yourself, you can sign. This stuff that they prepare on the other side, don't sign. I've even been through the process, where they take all your clothes and any belongings you got on you, and then they slip out a contract there for you to sign. Well, I don't ever give them permission to take anything from me. And that's what that is. That's permission. I just say, don't lose any of it. And then when they want to give it back to you, they want you to sign relieving them of liability of it. No. It just better all be there. Don't sign. I've been through one total, complete process from beginning to end. And that sign my name was. When it was not a piece of paper that I created for the purpose of a defense. Man, it sure makes your time being reduced to freedom. It shortens it dramatically. I know one day an officer came in, slipped a cart under my stuff, and wheeled me to the property line. And instructed me that if I returned, I would be charged with trespass. Well, of course, I had no intention of returning. I just bought my freedom by asserting my constitutional rights. Not with money. Because when I entered the process, I had 30 cents. And when I was carted to their property line and ordered not to return, the 30 cents was in my pocket. They hadn't lost the 30 cents. Are you hearing me? And I didn't sign for anybody to take anything, anywhere, anyhow. Now, all of those people in that whole system handle what is called trust funds. Hear me? Trust funds. Well, the word trust, that confuses some people because you look around and then you start to wonder, who in the world can you trust? Well, the truth of the matter is, none of them can be trusted. Are you hearing me? None of them can be trusted. So, and the government knows that. In its own nature, it knows that none of these officials can be trusted. So what does it require in most cases? I'm talking about most cases now. For them to stay in trust, they got to have your signature allowing them to spend that money. Now, did I say this went by you? They got to have your signature to spend that money. If they can't get the signature, how in the world are they going to dun the taxpayers for your keep? Dun means bill them. These are trust funds. All of them. In this one place that I was, and I'll probably never get to visit it again, but they have a budget through a quarter, and that requires every inmate's signature, because you see they got to count heads, and the only way they can count heads is not because you're there, but because you give them your signature. And these budgets are only for the signatures that they have. Well, part of this one quarter went by, and then into the next quarter, guess what happened? It caught up with them. They were missing one. Uno's, number one's signature, right on the dotted line. And they had to take up a collection. You hear me? The last day of the quarter, they had to take up a collection, not from the inmates, but from all of the officials that were running this place of higher learning. They had to collect money from them, from all the ones that worked there, to buy breakfast cereal for the inmates, because they were missing signature of number one, me. Now you hear me? It shows up. And when they realize that you is it and you is the cost, and they can't get the taxpayers' money to run that place on your name without your signature, I don't want you there. You're poison and you're liable to spread. You're like the plague. You hear me? Also, they need your signature to relieve them of liability. All over the place. Many signatures. They give you, I mean, you can have a signature for everything. You got to even sign for privileges in the kit. Discrimination. I don't sign a contract, so you're going to discriminate against me? Have at it. Are you in any position to do anything other than not sign? No. But that's the most important position of all. You're in the position of not signing. And that controls the system. Remember now? Government. This is our contract with you. You all have to take an oath of office to uphold it. Failure to do so is you're impersonating an official. That's serious stuff now. You can't do that, you hear? You can be prosecuted criminally yourself if you don't take this oath. So those of you listening to this that haven't taken this oath better get one done. Now, the law requires, this law requires that you take that before you commence the office. So very likely, if anybody finds out about the fact you didn't sign an oath of office prior to taking your official capacity and working at it, everything that you've done from then till now can probably be voided. And probably whatever you've been paid for doing that can be requested back. Because you can't impersonate officials. And also, officials, I think it's time you read this. So if you need one, you should call the congressman, senator, and get one. This has been giving them out so far. You need to be carrying this. It minimizes your exposure, your negative exposure to the public. So officials, let's get on it. Normally I got to talk to these people that you're performing rape and pillage on here. But, I respect your position and what you're supposed to do. Just get on it. Let's start doing it. It isn't that complicated for you. You get this little book, read it, study it, and start applying it to your position. and things is going to go a whole lot better. We'll start administering justice here. And that's what we all need to do. Every citizen. You know, and I'm a member of this contract here. I've taken an oath to uphold this contract. That's why we're of the same association. I mean, if you haven't taken an oath to uphold this, you oughtn't to be listening to this tape. You know, because none of what I said here applies to you. That's important. Remember now, under the First Amendment, you have the right to be free. You got a right to attempt to obtain happiness. It's called life, liberty, and the pursuit of happiness. Nobody's going to guarantee in any contract you're going to be happy. But when you start asserting this contract, at first you might not feel happy. But once you start and get on a ways, you'll start enjoying living like you ain't never seen it before. Because you will recognize what freedom really is, what liberty really is. It's knowledge. Possess it. And then whatever comes down the road, you can deal with it. Don't run off and hide. Don't dig out the billfold and pay. My goodness gracious. You're waiving your right. And I mean, this is awful important now. I've said many times, I am surprised that this country is as well off as it is because of the lack of knowledge of the law. We are a nation of laws. But nobody knows what they all are. And we're creating more every day. Let's keep with the basics. I like to look at all of these other books that require all these other statutes that require you enter a contract before they apply to you. I look at it this way. Hey, here's the contract, here's the law. All of these other books were written for the purpose of evading this law. So you can go into a law library and you'll see it. I mean, shelf after shelf after shelf of books. And you can assume that all of those were printed in an attempt to get around that. You don't let them get around that. You possess that contract, you hold it. And you can recall officials that aren't upholding this contract that have taken the oath. And you can request prosecution of officials that haven't taken the oath. This is required now, this oath. It's absolutely required. Otherwise, they're impersonating an official. I liken what they're doing to the finest form of organized crime I've ever seen or will probably ever see. And the only way you manage that is to manage government, because that is the finest form of organized crime I've been able to find. All other, when and where it exists, is unorganized by comparison. You hold this contract, you must assert it, and you must defend. Otherwise, organized crime wins. Are you hearing me now? Wish you the best. Don't give up any of your rights, including the right of appeal. Take it all away. It's your duty as a citizen. If we don't all stand up on this contract and uphold it, it weakens it for all. So let's do it. Live free, possess liberty, knowledge, and may God bless you.